Hi everyone, and welcome to video 4.1.3 for the Legal Studies guy. As always, we will start today with a quote. Today's quote from the Dalai Lama, who you might have heard of, the spiritual leader of the Tibetan people and the global leader of what we would call Tibetan Buddhism, so a branch of Buddhism, one of the I guess more major religions in the world. And this was a quote from the Dalai Lama when he was asked about, I guess, what his religion stood for at one point, and he said, "My religion is very simple. My religion is kindness. This is just that reminder to be kind to each other, and we're all going through human existence together. Yes, right now, maybe in year 12, ours feels a bit difficult, but that doesn't mean we can't be kind to others. So perhaps a reminder to, say something nice to someone tomorrow or today, or, a bit of a random act of kindness that you might be able to fulfill in your life." 4.1.3, this will be a pretty quick video. Here we're looking at the significance of section 109 of the Australian Constitution. Now, really, I guess, important to understand, and probably something that I didn't unpack in either of the previous two videos, is just the importance of what the Constitution is as a document, full stop. And I would hope that you have this underpinning foundational knowledge already, but it is worth just quickly outlining what the Constitution is. The Constitution is effectively it is the founding document of Australia as a country. It is the document, and as you've seen from the list of Section 51 in the previous video, it is the document that establishes how our federation and political system works. It's the document that establishes Parliament. It establishes the High Court. It's effectively the rule book at a really 50,000 foot approach, I guess, for exactly how Australia should operate as a country. And then from within that rule book, through Parliament, etc., and the establishment of government and the role of the Governor General and the High Court, we actually then get all the ins and outs of how our country runs. So those daily decisions and the laws that are made and the adjudication on those laws. But effectively, the Constitution is the founding document of Australia as a country that sets out the rules for how we operate. And as we learned from video 4.1.2, this includes the lawmaking powers of the Commonwealth parliaments, and therefore the things that are left out are the lawmaking powers of the state parliaments. And we would have, as we looked at in video 4.1.2, we looked at specifically this idea of concurrent powers. So concurrent powers being those powers that are shared by the states and the Commonwealth. And today we're going to talk about what happens if the states and Commonwealths pass contradictory laws or pass laws that, if you abide by a state law, you would actually be committing a Commonwealth offence. Or if you abide by a Commonwealth law, you're actually committing a state offence. And this is what Section 109 covers. And hopefully at the end of this video, you'll be able to explain what Section 109 is and why it is important. So as I said, what happens if a state and Commonwealth Parliament have contradictory laws? So what if a state and a Commonwealth Parliament make laws that are actually in opposition to each other? Now, one of the easiest examples to consider here is the concept of marriage. Now, as we know, marriage is a concurrent power, which means it is in the Constitution, and you'll see it here. It's listed in Section 51, so the Commonwealth can make laws for it. But it's not exclusive to the Commonwealth, which means the states can also make laws about marriage. Now, it's changed since we had a plebiscite about 5 or 6 years ago now, and the legalisation of same-sex marriage in Australia. So marriage just has to be between two consenting adults. But prior to this, the Marriage Act very clearly said this is the Federal Marriage Act, so Commonwealth. The Commonwealth Marriage Act said marriage must be between a man and a woman. So that's a really, really clear law. For a marriage to be valid, according to the Commonwealth, it must be between a man and a woman. But because marriage is a concurrent power, which means states can also make laws on it, what would happen? So, what would happen if Victoria then went and made a law that said marriage must be between two consenting adults? And say you had a couple in Victoria that were both male or both female, for example, and that couple said, hey, we want to get married, and the Victorian law says that it just has to be between two consenting adults, and they go and get married. And under Victorian law, that marriage is legal, but under Commonwealth law, that marriage is not. What would happen? So, what would happen if the state and the Commonwealth Parliament had contradictory laws? And luckily, when they wrote the Constitution in the 1890s, they thought about this problem. They thought about the fact that we would have concurrent areas of lawmaking power where states and Commonwealth could make contradictory laws. And this is exactly what Section 109 of the Commonwealth Constitution says. It says, when a law of a state is inconsistent with a law of the Commonwealth, the latter shall prevail, aka the Commonwealth wins. Really, really important that you understand this. The Commonwealth prevails, and the former shall, to the extent of the inconsistency, be invalid. So the Commonwealth wins, and the state law is invalid, meaning the state law no longer exists. The state law is struck out. What is really important, though, and past exams have shown us this in the examination report, is this section of Section 109, this little set of 6 words is vitally important to include in your answers. And this is the concept that the state law is invalid to the extent of the inconsistency. Now, I can't stress this enough. If you just say the Commonwealth prevails and the state law is invalid, or the Commonwealth prevails over the state when explaining Section 109, and you don't include these 6 words, your answer will not be fully correct. You will not have shown a full understanding of Section 109. You must point out that the law of the state is only struck out in terms of that single section that is invalid. For example, okay, and I've got another example here that I'll run through in a moment. But for example, and this actually, I think Tasmania decided to change the law without actually losing a High Court case. But there was an example in the 1990s where Tasmania had a law that, or Tasmania had their criminal code. So you might be familiar with the Crimes Act in Victoria, which lists all the crimes. Tasmania has a similar thing called the Tasmanian Criminal Code. And one of the laws in the Tasmanian Criminal Code was that it was illegal, effectively, to be homosexual. So it was illegal to engage in sodomy, was the term used, which meant if you were a gay man, it was illegal to have sexual relations with another man. So if you were a man, it was illegal to have sexual relations with another man. At the same time that law was in existence, there was a Commonwealth law that clearly said it was illegal to discriminate against someone based on their sexuality. So on one hand, you have a Commonwealth law that says someone can't be discriminated against based on their sexuality, and then you have a Tasmanian state criminal code that clearly discriminates against someone based on their sexuality. What happens here is the Commonwealth law prevails, but Tasmania's entire criminal code, so every criminal offence in Tasmania, isn't made invalid. The entire Tasmanian criminal law isn't struck out. Just that one individual section is. Because the state law is only invalid to the extent of the inconsistency. Now, a similar thing happened with IVF laws in Victoria. And this is an example of, again, an area of lawmaking power, in this case, that's actually residual power, that ended up being contradictory with a Commonwealth an execution of a Commonwealth seemingly exclusive power. Victoria, because IVF wasn't around in the 1890s, therefore, wasn't included in the Constitution, and health isn't included in the Constitution. IVF infertility treatment laws are considered to be a residual power or a power of the states. So Victoria had a law called the Victorian Infertility Treatment Act, and as part of this law, Victoria basically had a set of rules for who was able to access IVF treatment. And one of the rules, or one of the sections of that law, was that you were only able to access IVF treatment if you were, as a female, living with or married to a man. So basically, if you were a single woman, or you were a woman in a same-sex relationship with another woman, or if you had a long-term partner, but perhaps for some reason you weren't living together and you weren't married, you weren't able to access IVF. So this policy was, in a way, discriminatory. It very clearly said that you could only get IVF if you were living with or married to a man. This is despite a law from 1984 made by the Commonwealth saying it is unlawful to refuse service to someone on the basis of their marital status. So in Victoria, you can't get IVF. You're being refused service unless you're married. But the Commonwealth law says you're not allowed to discriminate against someone based on their marital status. So we can hopefully see how these two laws are inconsistent, or in a way, incompatible. They both cannot exist. They both cannot be true at the same time. So a doctor, John McBain, an IVF doctor, he actually took the state of Victoria to the High Court. This is an important thing with Section 109. The High Court has to decide if the laws are incompatible. The High Court has to decide which sections of the law are incompatible and decide which law prevails. This IVF doctor, John McBain, he took the Victorian government to court on behalf of a patient who was a single woman who wanted IVF. She wanted IVF and the Victorian law said she couldn't have it. He said, hey, the Victorian Act is clearly discriminatory. The Victorian Act says that she can't have IVF because she's not married, but the Commonwealth Act clearly says that that's not allowed. The High Court found in favour of McBain, and the High Court found that the Victorian IVF Act is invalid. So this is a really important point. The Victorian IVF Act is invalid as far as it says that only women living with a man can have IVF. Every other rule in this piece of legislation, every other part of the IVF Act remained in force. It didn't completely remove or annul or invalidate every IVF rule in Victoria, and it didn't completely tear down Victoria's IVF system. It just removed that one clause. So every other aspect of IVF continued to operate in Victoria, but now if you were a single woman or if you were a woman in a same-sex relationship, you could now access IVF because that part of the law was made invalid by the High Court. So can't stress that enough. How does Section 109 operate? Well, if two laws are incompatible, someone has to bring a case to the High Court, and only then can the High Court rule a law invalid. So, explain the significance, and this is actually, I think, it might be skill 415, and I might have that wrong. Explain the significance of Section 109 of the Australian Constitution, and sorry if I have that number wrong. This is a question from a past exam. Why is it possible for a Victorian law to be in conflict with a Commonwealth law? So why can a state law be in conflict with the Commonwealth law? In your answer, describe the impact that Section 109 of the Commonwealth Constitution could have on the Victorian law. So what impact would it have on the Victorian law, not the Commonwealth law? And hopefully, this question was done pretty well by students, an average of 2.8. So we'll just get back into the answer there. So an average of 2.8, done pretty well. And this was the suggested possible response from the examiners. And I want to note here the use of two paragraphs, really important to break up the two parts of that question. First of all, why is it possible for a Victorian law to be in conflict with an existing Commonwealth law? Well, that should be pretty straightforward, and that's our understanding of dot point 4.1.2, the different types of lawmaking powers. It's possible for a Victorian law to be in conflict with an existing Commonwealth law because of concurrent powers, that there are lawmaking powers that are shared by both parliaments. We've also seen, so such as marriage, it's possible for two laws to be in conflict. We've also seen that laws can be in conflict even if they're made in two separate areas. So a law made in IVF could be in conflict with a law made around anti-discrimination. And that law was made under the Commonwealth's external affairs powers because that was in response to a treaty that they'd signed. The Tasmanian example, Tasmanian criminal law, so the Criminal Code of Tasmania, residual power, in conflict again with a Anti-Discrimination Act passed under the Commonwealth's external affairs power. So two laws from two different heads of power can also be contradictory, or areas from within the same head of power, so areas within concurrent lawmaking powers like marriage, like my initial example, could be in conflict with each other. The second part of the question is describe the impact, so the significance in a way, of Section 109. If the law is challenged in the High Court, this is an important point, so must be challenged in the High Court for Section 109 to apply. So Section 109 doesn't come into force automatically. It's not someone in an office somewhere, a government bureaucrat who decides that Section 109 must apply. It has to go to the High Court. So if a law is challenged in the High Court, the High Court has the power to determine whether the Victorian law is inconsistent with the Commonwealth law. And if the Victorian law is inconsistent, okay, to the extent of the inconsistency, it will be deemed invalid. I can't stress how important these 6 words are. Again, to the extent of the inconsistency, or to the extent that section of Victorian law is inconsistent, not the entire Victorian law. That means parts of the Victorian law which are inconsistent will no longer be law in Victoria. But the remainder of the law, if there are aspects of the law that are consistent, will remain in force. But again, really, really clear. For Section 109 to come into force, the law must be challenged in the High Court. The High Court gets to decide. And then the Victorian law will only be invalid to the extent of the inconsistency. Here are some links again. I keep linking you the PEO, the Parliamentary Education Office. I recommend having a look. And also this link here, and I'll just show you, discard my, I'll load this one up, skip the verification. This will actually run you through a little bit around the facts and the decision made in the McBain case. So it's just going to unpack that inconsistency a little bit more, and how Section 109 of the Constitution played out. So if you're feeling like you're a little more advanced with this and want to read some case notes in a little bit more detail, I would recommend checking out that link that I post below as well. Ultimately, hopefully now you can answer that essential question. You can explain what Section 109 is, and you can explain why it is important. And particularly, you're going to be really strong on the idea of to the extent of the inconsistency. Happy studying. Always open to feedback in the comments below.